The subject of Jonathan's talk is Reconceptualizing Courts in an Age of Terrorism. Please go ahead.
Okay. Thank you. I think there's just so many interesting comparisons, having worked on the national security and focus on the U.S. between the U.S. and Israel. So it's just really fascinating for me. So what I want to talk about now is the U.S. The new U.S. military detention system, which has arisen really since 9/11, and the development of alternatives to what was the only forum for, or the main forum for the detention and prosecution of terrorism suspects, the federal courts, the civilian courts, and the impact that this new military detention system has had on the federal courts, and what it means and what happens, or what's happened in the United States when you have a development of these kind of specialized terrorism courts and how they impact the regular federal courts, which they do in a number of different ways. So to briefly just sketch the history, which many of you are probably generally familiar with. So before 9/11 in the United States, terrorism suspects could only be subject to prosecution or long-term detention through the regular federal courts, called the Article III courts in the United States. There were, we have immigration courts, and so they obviously had detention powers, but those were somewhat limited, and the theory was that the detention there had to be in connection with the person's deportation from the country. It wasn't meant to be a mechanism for the long-term incapacitation of terrorism suspects. So after 9/11, with the war on terror, or it's more precisely defined, the global armed conflict with Al-Qaeda, the Taliban, and associated forces, the U.S. developed an alternative military detention system, which has really two main features. One is a system of military commissions, which are held at Guantanamo and are used to try terrorism suspects for war crimes, and those have been now they are now implemented through congressional legislation. They've been adopted and utilized by the Obama administration, so they're more or less a permanent fixture. And the second is through indefinite detention. This was done under, initially done under a statute, a broadly worded statute in the United States called the Authorization for Use of Military Force, which essentially was Congress's approval after 9/11 to go after the individuals who were responsible for 9/11 and laid the background for the U.S.-led invasion of Afghanistan, and it subsequently became the basis for detaining terrorism suspects as enemy combatants, and they could be held for the duration of the conflict with Al-Qaeda and associated forces. So you have this long-term detention, and consistent with the general theory of the of international humanitarian law, as argued by the administrations, these enemy combatants could be held indefinitely. They didn't need to be charged. So you have after 9/11 and today these three options. You have the federal courts remain and are still utilized for terrorism prosecutions, although no longer for the prosecutions of any Guantanamo detainees. And then you have military commissions, and then you have indefinite law of war detention. And so what I want to highlight is some ways that the rise of this alternative military system has actually impacted federal courts, the regular courts, which in fact are the principal mechanism used for, at least outside the current population of Guantanamo detainees, for treating terrorism suspects. And so one thing that you've had is this a high degree of politicization, where in fact questions about federal courts viability that never existed before. So with each new arrest in a high-profile terrorism case, for example, the terrorism suspect Abdul Muttalib, the guy who tried to explode the underwear bomb on Christmas a couple years ago, right? Any kind of new high-profile terrorism suspect who's arrested, you get a question about where should that person be tried, and you get a political battle over whether or not they should be put into the regular federal court system or should they be subjected to this alternative military detention and trial system. You saw this also with the most high-profile suspect in U.S. custody, the Khalid Sheikh Mohammed, the self-proclaimed mastermind of the 9/11 attacks, where the Obama administration, in late 2009, said we're going to prosecute him in federal court, in the regular courts, and that unleashed a huge backlash, and the administration was forced to change its position and prosecute him in the military commissions. And in fact, Congress led to legislation barring the trial of any Guantanamo detainee in federal court, so closing that off. So there's a whole a very highly politicized atmosphere now around using federal courts, and partly in response to that, the federal courts, to justify the use of federal courts, both prosecutors as well as advocates and even civil liberties groups will now emphasize the federal court's ability and success in convicting terrorism suspects. So the metric for the success of federal courts is not fairness anymore. That's not the virtue. It's that they are successful at obtaining convictions and actually at how tough they are. And just as a brief aside, you get which is a sort of a irony in relation to the last talk. Actually, the sentences in federal court are often higher than in the military courts, the military commissions in the United States. Anyway, so so federal courts justify themselves through the fact that they're tough on terrorism as opposed to fairness, and relatedly, their legitimacy depends, these days, on obtaining convictions. So whenever any high-profile terrorism case is tried in federal court, even those who advocate using federal courts will suspend their criticism of things that the federal courts might do and are just and hoping for conviction. Anything short of a conviction undermines the case for using federal courts. We saw this with the case of Ahmed Galani, who was the only to date, the only Guantanamo detainee who's been tried in federal court. He was charged for his role in the 1998 embassy bombings, and he was actually, although he was convicted of conspiracy to destroy government property, was actually sentenced to life in prison, but he was acquitted of the counts involving the conspiracy to commit murder, and even because of that, it was looked at as federal courts became a risky option. Right, so even that one case where the guy was convicted, it became, well, federal courts are too risky. Someone might be acquitted. We can't use them. We need to go with the military route, which are viewed as more secure. And then, additionally, there's a pressure, or it's created a pressure to diminish rights in the federal civilian court system. For example, the speedy trial right has been undermined. So you have this was the case of Gailani. Again, is instructive. You have someone who was held in a CIA prison for 3 years, then at Guantanamo for 3 years, and then was brought to federal court in seeming contravention of the right to a speedy trial. But in order to show federal courts were a viable option, the court essentially sort of held its nose and said, there's no speedy trial violation for various reasons. We see this also around the Miranda protections, the right of criminal suspects to be given warnings following their arrest, and there's a exception to Miranda for what's called the public safety exception, where you don't need to read a suspect their Miranda rights to obtain information quickly to prevent crime, and that's been stretched in the terrorism context, and again, that's in order to make federal courts viable and to address criticisms that federal courts aren't a viable forum for prosecuting terrorism suspects. In addition to the way the perception and role of federal courts has changed in criminal cases, I think this alternative military system and the criticism of courts that it rests on, of civilian courts that it rests on, have had implications in the case of civil remedies. That is, the ability of individuals who've been aggrieved by torture, other abusive interrogation practices, or arbitrary detention to obtain some kind of civil remedy. In fact, to date, there's no individual who's been detained in connection with the war on terrorism, including several U.S. citizens, has been able to actually not only have they not obtained any judgment, no one's actually been able to get to a trial on the merits. All the cases have been dismissed on various threshold grounds. And so these threshold grounds, they include things like state secrets and other doctrines, are basically they're used to keep essentially victims out of court, but they rest on these characterizations of federal courts, the same ones that are used to justify the creation of specialized court systems. So for example, you have federal courts portrayed as unable or to handle classified or sensitive information, unable to adjudicate cases without interfering with diplomatic concerns, a whole bunch of different reasons that underpin these doctrines, like state secrets defense, that prevent federal courts from providing a remedy to victims of torture or other abuse. A good example from the state secrets context was a case called Mohammed versus Jeppesen, which involved a civil suit over the U.S. government's extraordinary rendition policy, which you all probably know involved the moving of terrorism, the deliberate secret detention and outsourcing of terrorism suspects for torture, and the plaintiffs brought suit against the company that operated the charter flights with knowledge that it was being used for this rendition program. And there was the plaintiffs in that case filed something like 2,000 pages of or 2,000 documents demonstrating how the public nature of the rendition program and the public nature of the statements that the defendant airline charter company was aware that what the company was, that they were involved in these torture flights, and yet the court sustained a motion for dismissal on state secrets grounds without ever reaching the merits. And the theory was that even if the plaintiff could prove his case with public information that was in the public domain, there would be too much, courts would be unable to weed out information that was a state secret from information that was public, in either allowing the plaintiffs to press their case or having the defendants raise their responses. And so a court really couldn't, despite the fact of all the information that was in the public domain, the courts would not be able to weed out what was sensitive and classified from what wasn't. And again, this was a sense in which courts were not, federal courts and federal judges were not competent institutionally to handle terrorism cases, and then secondly, that these type of issues should not be litigated in federal courts. And a distinction with the prior point about the use of military courts for military commissions. Here, there's no other court, so there's no forum for any kind of remedy. It's the federal courts or nothing. Finally, I just want to turn to a third area where we've seen an impact on federal courts from the creation of this alternative military detention system, and that is on the courts now essentially sit in review of the military commissions and of the law of war detentions. So, and I think the second case, the law of war detentions, is particularly instructive. What's happened as a result of years of litigation is that it's been established that the detainees held as enemy combatants are entitled to habeas corpus. So they're entitled to judicial review of their continued detention. And so you now have, for the last almost 4 years, you've now had the various Guantanamo detainees challenging their continued detention in federal court through habeas corpus. So you now have these federal courts in a way acting as almost de facto national security courts and reviewing the case of the military detention. And the courts have largely upheld the government's authority to hold terrorism suspects on the theory that they're enemy combatants, and have provided some modicum of procedural protections. But these habeas corpus cases look increasingly unlike criminal trials, and essentially this is still the issues haven't been decided, and the Supreme Court has yet to weigh in again. But you essentially have extensive use of classified information that detainees don't have access to. You have a highly deferential view of the government's allegations. You have limits on what we might call other fair trial rights, such as abilities to the use of hearsay and ability to confront witnesses. And again, what you see is a lot of the arguments that were sort of lie behind the creation of the alternative military courts, military commissions, are now being applied within the federal courts themselves in reviewing those military detention cases, where the courts are unlikely to or very reluctant to challenge the government's allegations, to challenge the executive's claim for necessity to detain. And so you can see in this area as well kind of the impact that this alternative military detention system is having on federal judges and on federal adjudication. So to conclude, I would say that the creation of these specialized alternative military detention system has reshaped or is reshaping the role and perception of federal courts as forums for criminal prosecutions and as forums for civil remedies. And we've also seen the creation of a new species of federal adjudication to hear challenges to the military detention system itself, and you see, in fact, the federal judges very, very cognizant and very self-aware of their own perceived limitations in adjudicating these cases.